Hello, I'm Dwight Golan.
I'm Marjorie Corman-Aaron. Because of the increased use of mediation to resolve difficult legal disputes, we produced this video. It shows the mediation of a typical commercial contract case involving claims of breach of warranty and unfair insurance settlement practices.
The mediation was not scripted, and the mediator was not given access to the parties' confidential information. Instead, we told all of the participants to go forward as they would in an actual case. We've edited more than 4 hours of original footage, but we've tried to preserve a sense of the flow and the progression of an actual mediation, to highlight the obstacles facing the neutral, and to show how we responded to them. This case involves a lawsuit over an allegedly defective product. The plaintiff, Waltham Construction Company, bought several barrels of antifreeze from Foster Fuels and put it in the engines of 70 heavy trucks. Waltham claims that within a few days, the hoses, seals, and gaskets in the cooling systems of 6 of the trucks began to corrode and leak. Waltham says it had to overhaul the engines of 21 trucks and that 49 more remain in jeopardy. Waltham has sued Foster Fuels. It has also sued Foster's insurer, who, it argues, acted in bad faith by refusing to make any offer to settle the claim.
Foster Fuels denies that its product was defective. No problems were reported by other customers who received antifreeze from the same batch. Foster maintains that it had never received such a complaint in the past. Foster's expert conducted scientific tests of samples of the antifreeze from the batch in question. These tests revealed nothing wrong. The insurer says that, based on the negative test results, it was fully justified in denying the Waltham claim.
Waltham claims damages totaling $1.535 million, made up as follows. First, the overhaul of 21 trucks. Second, lost market value to 49 other trucks. Third, interest, attorney's fees, and treble damages arising from the insurer's claimed bad faith. Foster Fuel argues that Waltham's claims of damage are greatly exaggerated and the claim against its insurer is baseless.
The mediator is David Hoffman, a civil litigator with the firm of Hill & Barlow in Boston. David teaches mediation at Harvard Law School and is a co-author of a book on dispute resolution.
The parties and counsel are, for the plaintiff, Thomas Bean of Nutter, McLennan & Fish, outside counsel, Nathan D. of Suffolk Law School, Vice President.
And for the defendants, Craig Stewart of Palmer & Dodge, outside counsel, Professor Linda Samard of Suffolk Law School, inside counsel.
My name is David Hoffman. I'm the mediator who's been assigned to this case. And I want to begin by just going over some of the ground rules, the process, make sure everybody's comfortable with the way this process is handled. The most important thing that I want people to understand about the mediation process who've not been involved in it before is what my role is. I'm not a judge. I'm not here to decide the case. My opinion about the case is really irrelevant to the outcome if you wind up going back to court and litigating. My role is simply to be a facilitator of the negotiation. And the purpose of the mediation process is to see if, by working together, we can come up with a solution that works better for you folks than the alternative, which is to go back to court and continue the litigation. And if we can do that, great. If we can't, why, the court is there and the case will continue. And at any point along the way this afternoon, if you feel the process is not working, you're free to say, we've done enough mediation. We don't feel like we're getting anywhere.
The mediator stressed the confidentiality of the process, noting that the parties had agreed not to disclose anything said in mediation to any outsider or in any subsequent litigation. He noted his own agreement to hold confidential anything that the parties disclosed during a caucus session. The mediator also described the process as an informal one and suggested that they go forward on a first-name basis.
Both of the parties here are businesses. You had business dealings in the past. We may want to talk about whether business dealings in the future are likely, possible, whether structuring those relations in some useful way as part of this process might be something that you want to discuss. It may not be something you want to discuss. But the orientation toward the future, to figure out what each side's essential interests are on a going forward basis, that's one of the things that makes mediation different from going to court. What I find in most cases is that having a joint session in which all 5 of us are here in the room we start with a joint session to hear from each side. I find that often works best. At some point along the way, it may feel like the right thing to do for me to meet separately with each side. What I'd like to hear from you are basically three things. The merits, and I'll speak to that in just a moment, the procedural posture of the case, and settlement discussions.
The following are brief excerpts from each side's opening presentation.
I guess what I'd encourage you to do is focus on the issues with respect to the merits, whether it's liability, damages, or both, that you think are the most salient issues that have kept this case from settling. Does all that sound okay to you folks?
Yep.
Good. And the idea of beginning with plaintiff and then defendant?
Sure.
Fine? Okay. So, Tom, the floor is yours.
I think the merits are pretty simple, David, and really speak for themselves. I don't want to rehash all what's in the memo as you requested, but Waltham Construction Supply Corporation, which I represent, had purchased diesel fuel from Foster's for years and had had a good relationship. Mm-hmm. And a few years ago, we needed some antifreeze, and Foster's was soliciting our business. Foster's knew we had dump trucks, large trucks. They brought us some antifreeze. And the reason I say this is easy, because the memo almost suggests this is a res ipsa loquitur case, mm-hmm. in terms of we put the antifreeze in our trucks, and within days, the engines started deteriorating. So whatever it was that Foster gave us, which we immediately put into the trucks after we received it, immediately caused the plastic and the neoprene to corrode. We've had to overhaul almost 24 engines as a result of this, and we don't know how many more we're going to have to overhaul. At a minimum, there's been a lot of damage to these trucks. Even if we don't have to overhaul an engine, their value on resale has been diminished. We understand Foster's is insured by Lloyd's of London, and Lloyd's came in, looked at it, saw the damage, and for reasons that frankly shocked us, denied the claim. Our damages are outlined in the memo, $1.535 million, and we've not received a response, and we're not sure why.
Nathan, just so you understand, Foster absolutely understands that you've got a problem here, that you've got 21 trucks that have had to have an overhaul. The problem that we have, and frankly it's been a problem right from the outset, is that you view this case as being absolutely tied up and simple, and it's not. We've got major problems with your theory that it's our product that's to blame. We have major problems with regard to the amount of damages which you claim to have suffered as a result of our product. The facts that we know are that we delivered 3 55-gallon drums of our antifreeze to your various depots. Several days later, a couple of your trucks began to have leaks. Now, the implication, the innuendo, is that somehow it's our antifreeze that has caused those leaks, without regard to any other cause, without regard to the condition of the truck, without regard to other things that I'm going to mention. What we don't know is what was the fluid, what was the coolant that were in these trucks at the time that our antifreeze went into those trucks. What chemicals were in that coolant? Were the systems, to the contrary, perhaps drained in those trucks prior to our coolant being added? There's a number of issues that we have just begun to take discovery on. What we, and a lot of those issues, frankly from us, remain totally unknown. And my suspicion is they remain unknown to you as well. What we do know is that we've been in a company for we've been in this business for 15 years. This is the first time we've ever had a problem with regard to our antifreeze. We encountered no other problems from any other customer. So we have this mystery of why, and there's a lot of things about your operation and your trucks and the composition of coolant in your vehicles, as well as, for that matter, the composition of the rubber, the neoprene, the age of the trucks that we'd like to know more about. And we think you're going to have to prove, certainly, if you take this thing to trial. Our expert, a PhD chemist at MIT, has analyzed the coolant taken from a sample of the coolant taken from the trucks that were affected, and has determined that there is no corrosive chemical in that antifreeze which would cause the damage that you're talking about. And also, we've got real problems in terms of this $10,000 amount that you paid this company that you've been using. We don't know what the relationship is, frankly, between you and the overhaul company. But just because you paid it doesn't mean that it's a fair amount to pay for an overhaul. And we do have, we have talked, Linda and I have talked, and we are prepared to make a proposal, but I think the appropriate thing to do, frankly, would be to talk to the mediator and make the proposal to the mediator. Linda?
Really, putting aside the personal issues that Nathan has already flagged, in the interest of sort of keeping a settlement posture on the whole mediation, I think Craig has done a good job covering our position.
What I usually do is to give each side an opportunity to respond to points that have been raised by the other side. We may go back and forth a couple of times to clarify, a piece of information that, sometimes to clarify issues. I have a few questions, but I think I'll hang on to my questions for the moment to see if, in your responses, they get answered. Tom, do you want to respond to any of the points that Craig and Linda made?
Be happy to. One of the questions you had was what product we were using before. We were using a Texaco product in these trucks before we put in your antifreeze, and we used a Texaco product afterward.
A couple of questions that I have, and again, I want you to feel comfortable talking to me about these issues separately in a caucus session if you're more comfortable doing that. But one of them is, if this matter were resolved, do your two companies have an interest in resuming a business relationship? I take it there is no business relationship now with the litigation going on. Is that true?
That is true.
Yeah.
I think it's possible. From our perspective, I don't think we would be so closed-minded as to just shut off any kind of relationship.
It would be very difficult for us to continue in a business relationship with Foster's, given what's happened. And a lot will depend on what happens today.
Okay. Well, that's helpful. I heard discussion about an expert witness on the Foster side. Has there been any identification of expert witnesses other than that one expert?
Yes, we have experts as well.
Okay. Lloyd's is not at the table. Is that right?
They're not at the table, but they are only a telephone call away, if necessary.
I'm inclined to meet with each side separately right now, if that seems good to you. Craig, Linda.
Yeah.
I usually begin the caucus session after a joint session by asking if there's anything that didn't come out in the joint session that you think would be helpful for me to know, with the reminder that if it's something you want me to keep confidential, just let me know that.
David, there is something, and we would ask that you, in fact, keep it confidential.
Mr. Stewart then summarized information from the maintenance records of the trucks, which, he argued, showed that the Foster antifreeze was not in fact put into several of the trucks that failed.
Well, let me ask you about this confidential information about the maintenance cards.
Right.
What they show, let me see if I understand what you've explained to me. The maintenance cards show that there are certain trucks that didn't have the Foster antifreeze, but did have this problem of corrosion.
Exactly.
And is it the case that there are some trucks that did have the Foster antifreeze that also have the corrosion problem?
That's what they claim. It appears that that is so. That's right.
So the corrosion that you've identified because you're expert, looked at the engine parts and so forth. Any theory about what caused it?
There are corrosive chemicals which can eat away at neoprene and rubber.
Yes, we sort of feel as though we actually tested the antifreeze that was used, that we delivered, and found nothing corrosive or no chemical that could have caused the corrosion. And therefore, since they bear the burden of proving that causation element, we've got a fairly strong case just on basic liability, because although they characterize it as being such a open and shut case and res ipsa, I guess from my perspective, I think that they're using the res ipsa argument because they don't have evidence to prove the causation. I think they have a major hole in their case there.
Our belief, and you can communicate that belief, our belief is that we're going to find that there was some chemical interaction between the Foster antifreeze and the antifreeze plus an additive, I believe, an additive that they were using prior to the Foster antifreeze being added into that system. Our belief is they did not flush the cooling systems in these vehicles adequately.
Now, when you say your belief, I mean, is this your expert?
They're working on it.
This is the expert's hypothesis.
Right, right. And I think that's the real problem.
Mm-hmm. What can you tell me about Lloyd's willingness or ability, in spite of the fact they denied coverage on this, since they're now in the case, they've been sued? Do you have some authority from them? Are they going to participate in making a proposal for settlement?
Well, Lloyd's has the indemnity and the defense costs and the alleged exposure for bad faith. Lloyd's, I'll tell you, is not contributing one nickel on the bad faith claim. When you have a PhD professor of chemistry at MIT who says there is no corrosive chemical in the Foster antifreeze that could have caused this damage, that eliminates any issue of bad faith.
Well, let me ask you this. You've talked about the trial costs,
Right.
Being very substantial for each side.
Mm-hmm.
Given what you've told me, that there really has not been proof forthcoming from the other side as to causation, that you have some questions about the damages, especially with respect to the trucks that haven't been overhauled. Given all that, why are you here?
We're here because we're going to have some people in the jury, obviously, who are going to say, hey, they were okay before the antifreeze went in, and they're not okay now. There must be something wrong. I mean, that's a reaction which we understand we're going to have to combat. I think we can do it because I think I know how to do it. But we've got that risk.
And I must say, there's a personal element, which I would appreciate if we kept confidential, but of course my father has spent 25 years of his life building this business, and he's obsessing over it. The personal side of things, you can't separate.
Is the reputational issue, publicity and so forth, a concern for Lloyd's as far as their denial of coverage is concerned?
Not at all. Not a bit. We get sued for bad faith all the time.
Okay.
It's a fact of the insurance business.
When I talk with the other side, they're going to ask if there's been a proposal.
Right. We've talked about this, and this is how we look at it.
Mr. Stewart then applied various risk factors and discounts to Waltham's claimed damages.
And we'll give them 70% of that value, 70% of the $55,000, which gets us down to $38,500, and that's our offer.
So let me see if I understand how you got to that number, and then I want to share with you some observations of my own. Let me ask you if there's any other component of a proposal that you've thought about you might want to consider.
What we mentioned previously, the privacy issue and the confidentiality.
Okay. Well, let me ask you this. What do you think is, they've made a demand of $1.5 million. And I understand from what you've said the reasons why you think that number is, way high. What do you think is the lowest number they would be willing to settle this case at? Do you have any sense of that? If you had
I
to
really
make a
don't.
guess, how far down the road in your direction do you think they might be prepared to come today?
If I were in their shoes,
Mhm.
they spent, according to them, $210,000.
And how much
I
are
don't
legal
see,
fees?
I don't see, that's, frankly, those are sunk costs. We've had legal fees too,
Yeah.
and I don't think that they,
60,000 today, I think
is that what they've said?
I think
something
that's what,
like
yeah.
Mm.
Yeah, something like $60,000.
So 210 plus 60 would get them, I mean, in their eyes, back to zero, and not counting if there is diminution of value in the other trucks. I'm sorry, but I interrupted.
Well, that may be helpful, but I mean, we've also spent $60,000, and I think that their ability to recover that at trial is frankly negligible. That is the attorney's fees.
Okay. Well, let me do this. I want to suggest two other possible approaches to settlement here, because frankly, I think if I communicate your offer of $38,500 plus a promise that they'll keep all of this under wraps, they very well might say, well, mediation's over. I've seen that happen, and perhaps you have seen negotiations end because of that. With a demand of $1.5 million, even if they feel that that gives them a good deal of room to move, they could very possibly say to you, that's not a strong enough offer, and they're not going to counter it. In which case, you're going to be in a position where you're going to be asked to bid against yourselves, which most parties are very reluctant to do. And so then we wind up in a bit of a stalemate. So whenever I'm mediating, I feel like it's part of my job to reason together with the side that I'm meeting with. I don't know what their reaction might be. They might think 38.5 is a good starting point. I have a gut level hunch that they will view that as pretty light.
Given Nathan's rather wooden demeanor, I would say that you're probably right.
Okay, okay. So we're sort of on the same wavelength here in terms of assessment of where they are.
Yeah.
So that leaves me thinking a few things. Number one, might it be prudent to move your offer to a number that is more likely to motivate a response from the other side? That's question number one. Question number two, might it be sensible to include in your proposal, or as an alternative, something about the possible business dealing?
Mr. Stewart then asked to speak privately with Ms. Simard. They came back a few minutes later with a new first offer of $75,000. The mediator responded by suggesting that they construct a rationale for this offer.
I don't know. I suppose we could.
What we could do is take, rather than only 11 trucks, we could take 15 trucks multiplied by the full 10,000 and then say 50% litigation risk. Make it very straightforward, and that gives us very close. That gets us 75.
Let's do that.
Okay, 15. So I want to make sure I can articulate the rationale. 15 times 10,000, so that gets you 150,000, 50% litigation risk.
The mediator also suggested that Foster propose the appointment of a neutral expert to investigate some of the disputed factual issues.
I think that communicates a certain level of confidence about the outcome, which might be useful.
Okay.
One thing that we discussed very briefly is we see the crux of settlement in this case hinging upon the double damages, the fact that we don't see any evidence to support their case in double damages or treble damages, and also the diminution of value. I mean, those are really the ones that we're not giving anything for because we see nothing.
That if they have evidence, that might influence your bargaining position.
Yes, and if they don't, we hope it influences theirs.
Let's see what information, if any, they come up with on the bad faith issue. Let's see what evidence they have, if any, on the diminution of value. I'd like you to consider, I may be with them as long as I've been with you, which is a good long time. I would encourage you to think about whether in the next round, let's assume there is a next round, let's say 75 isn't so low that they don't pack up their briefcases and head home. If they are going to make a counteroffer, under what circumstances would you put the card on the table that I think might substantially influence their number? The maintenance card. That's right. Play the maintenance card. Because, frankly, without the maintenance card, we'll see. We'll see. I suspect you will not get enough movement from them to settle the case, because there hasn't been the discovery. There is no neutral expert.
In the
That's
interest,
problem.
in the interest of time,
Yeah.
you know, maybe you get into the discussion with them for 5 minutes or so. If you're right in terms of where it's going, then come back to us, and we may go ahead and give you that authority.
I think that I now have a better understanding of their perspective on the case, which I will be able to, I hope, communicate to you so that you understand the basis of their proposal, because they've given me a settlement proposal to communicate. And we can start with that. We could also start with if there are any issues or concerns, things that you didn't have a chance to speak to in the joint session. Or
Let me talk about the trust issue.
Sure.
Something we're very concerned about, and I do want to hear what they have to say in terms of a proposal. One of the problems I think both sides have, and this is confidential,
okay,
is that nobody has a sample of the crud that they sold to us to put in our trucks. And we have serious doubts that the sample of fluid that they produced to us and they gave to their expert was indeed what they sold to us. That's one explanation. There's a second one.
Okay, but with respect to that testimony, which I take it you reasonably anticipate they'll so testify, what is the response to the jury other than we don't believe that witness? In other words, how can you demonstrate to the jury that it can't be?
Okay. We can't demonstrate that it can't be. But what we can demonstrate is that it doesn't necessarily, that doesn't mean that what they gave us was not defective. And here's the thinking. As you can see, it's about a third of the vehicles have had problems. It's our theory that oil, which we all know is heavier than most other soluble, most other liquids, would go to the bottom of these drums. And so it may be that what this fellow came up with, he took from the top of the drum.
I see,
But the top 2/3 of each drum
may have been fine.
May have been fine. And the bottom third, where the oil sank to the bottom, is where the problem is.
What do you know, what does Waltham know about the trucks that didn't have Foster antifreeze?
Well, that supports the res ipsa loquitur theory. We have a control group, if you will, of about 80 trucks, and we have the test group of about 70 trucks. The control group, which had the Texaco antifreeze in it, as it always had been, has not had any problems.
None.
Now, and that's, I mean, you've looked at the relevant records for the other vehicles. Is there anything that you folks know or your expert has concluded about what caused that corrosion?
We think it's oil. It's an oil-based product, which, that's why I was mentioning the oil earlier, is heavier.
And so that's what your expert will say. Okay. Now you've got a sample of this material in the hands of an MIT person who reports to Lloyd's, hey, there's not an issue here about, I mean, there's nothing in this material that our insured says they provided that could cause corrosion. So if Waltham trucks suffered some corrosion, it's not from this material. Now, if all that is the case, and if this expert is someone who is, you know, a credible person, how do you get Lloyd's into the case?
It's a problem, no question about it.
Is there anything else you want to share with me that didn't come out in the joint session or hasn't come out yet? I'm aware of the time, and I want to, you know, get the bargaining going, and at the same time focus on the issues that inform your position and your view of the likely outcome of the case.
I think one of the things that they underestimate is the damage done to the 49 trucks where there has not yet been an engine overhaul.
That's, you know, I'm glad you raised that, because that, in fact, is one of their concerns. They asked me to actually inquire about that.
Mr. Bean admitted that Waltham's claim for damage to the trucks that had not yet shown any corrosion was weaker. and might not total the full $5,000 per vehicle that Waltham had claimed.
We don't usually sell our trucks. We usually run them into the ground, and
Right.
that's standard practice.
Sure.
However, we would be losing the right to resale because of this stigma, so there has to be some value there. And the dealer said that it was in between $2,500 and $3,000 we've lost on each vehicle. I know that in our original damage claim we were talking $5,000, but we're not looking for a windfall here. We're looking just to be made economically whole again.
Okay, so since the time that the original demand was made, you've gotten this information from the dealer.
We went out, got the fair market value.
Yeah. 2,500 to 3,000 is in the dealer's view, the
Resale value for those trucks.
The diminution.
The diminution.
Diminution value.
The diminution
Yeah.
in value.
So that, in your demand numbers, that figure of 245,000 for the lost market value, based on 5,000 per truck, that number is going to come down. Okay.
But again, let's keep that confidential until we see where they're coming from.
Okay. So that's something you want me to keep confidential, and also for the time being, and also the issue of what your expert says about the corrosive effect of the sample, the fact that the sample may have been high in the barrel, not low in the barrel. So those are the two things you've asked me to keep under my hat for the time being. Now, is there anything else that you want to?
Just one comment I'd like to make is that just, businessmen, common sense. I'm not a lawyer. I don't go to court a lot. We've already lost a lot of money here. We don't mind going to trial. It's not really going to cost that much more in comparison to what's already gone down the drain, so to speak. And when you look at it, it's very basic. You're going to go in front of a jury and say, look, I put some fluid in my car, I put some fluid in my truck. Doesn't work. Also, people don't like insurance companies. So we have no problem going to court over this. We do want to solve it, but I think they need to know that.
And the PR damage, potential PR damage,
Lost business,
is quite significant.
And we're not going to threaten anyone, but reality is reality. If I'm having coffee with my friend who is also a dealer, or, does the same type of business we do, of course I'm going to tell them that I haven't had a productive relationship with Foster's, and if their business suffers by that, so be it.
I don't know is that a possible concern for Waltham?
But at this point, we're out of pocket a couple $100,000 for the repair of the trucks. We do have the attorney's fees invested. We do have a lot of time invested. We have the overtime from our staff that went back and pulled all the records on the trucks to do the comparison we were talking about earlier. Balance that against like $5,000 a month to get into trial, maybe another $20,000 to take care of the trial costs, and I think it balances out. At this point, we're in too deep.
It's 20,000.
It's probably a little light. Where are they in terms of numbers?
Let's go ahead. I'm glad you asked. I think that's the right place to go right now. Their proposal is based on the following basis. Number one, they don't believe that they haven't seen evidence of bad faith on the part of Lloyd's. They're open to hearing if there's evidence that you would like to share with them, unless and until there's information put on the table about bad faith on the part of what Lloyd's did. I think what you're going to be hearing from them, and what you're hearing now, is that they can't put value on that piece of the case. With more information, the situation could change. But they're not aware of any such information. And then they say that they view it as maybe a 50% risk of the jury believing your liability case versus their liability case. They accept at face value, and this is a compromise that they believe they're making in your direction, is to say 10,000, even though maybe someone else could have overhauled the trucks less expensively. 15 times the 10,000, 150, figure a 50% risk factor, and that brings them to 75,000.
They don't want to settle the case, in other words. David, I'm sorry. That's insulting, that offer. That's absurd.
What do you think would help them see that they have more exposure here than that offer suggests?
to respond, $75,000 and a confidentiality agreement is just, we're not in the same ballpark.
How do you think you could get them into the ballpark where you feel the case could settle? They are willing, they're hoping that this case could be settled, but they're willing to at least consider and negotiate about the appointment of a neutral expert to focus on the technical issue. I mean, clearly the reason that you folks aren't in a settlement range yet is you have very different views about, what happened, what caused this. Your view of the strength of the case, based on what I've heard from you, has a lot to do with the res ipsa loquitur feature of the case. And so you might want to consider making a proposal which is a move in their direction, which hopefully will lead to a, yet another round of proposal, another number from them. But communicating the view that in the absence of some reason to doubt that you're going to get an instruction on res ipsa loquitur, that in other words, that your liability case is sort of all but proven, that you're going to be in the range where whatever your offer is. Let's say, for example, if you would say to them, well, we'll take the bad faith piece of the case and let's, say for the sake of argument that we, put some kind of discount on that.
I'm comfortable. Are you comfortable with that? I think we're comfortable. We recognize that that's the weakest part of our case.
Yeah. Well, what percentage when you say low? 90%.
Yeah, I think with discovery, I mean, I don't expect.
Without
now
discovery.
It's lower than 20%. Do we have anything on the good faith?
Not that I know of, but I'm not the attorney. I just know my trucks are broken. Those people won't pay.
Right. I hear you. And that's so let's focus on the truck numbers.
All right.
And see if we can put together a proposal based on the truck numbers that would make, I mean, your objective, I take it, Nathan, is to be made as whole as possible. And according to my calculations, you correct me if I'm getting this wrong, 427, 490.
That's really good.
That would be a make whole number where you win. 100% chance of winning.
How much should they pay for the confidentiality agreement?
Attorney's fees.
Okay, we're talking numbers here that may not be acceptable, but may move the conversation along.
The discussion produced a damage figure of $487,500. Mr. Bean expressed concern, however, that if Waltham reduced its demand from $1.5 million to less than $500,000, it would send a bad signal to the Foster lawyers. Mr. D then proposed that Waltham's first move be to $750,000.
Additionally, they tried to discount it at 50% risk going to trial. 50% of 1.5 is 750. I mean, it's not technical, but just to throw out a figure, and then you could move down to this figure.
So I'm going to meet with the other side.
Okay.
You're comfortable with the rationale I've articulated, and then you can use the time to think about the next step.
Okay.
Good. Thank you. They have made a counter proposal. It's $750,000. I don't know if that surprises you as being higher or lower than what you might have expected. I want to give you some idea of what their rationale for being at that level is, and then we can talk about next steps. One of the things that I think it's important for you folks to hear is that based on what they now know about the truck piece of the case, they believe that they have a res ipsa loquitur case of damage to the trucks. And so it seems to me that if you want them to reassess their likelihood of success on the merits of the case, this is the time to put the maintenance card on the table, so to speak, because otherwise I think you're going to have a gap that is, maybe you'll come up some, maybe they'll come down some, but my hunch is you won't be able to close the gap so long as they believe they have a res ipsa loquitur.
I guess what is disappointing to me about this is that we weren't able to get away from even a piece of the bad faith side, because I think that still is a real stumbling block.
This is your case,
Right.
and you know, you have to make a judgment as to whether you'd prefer to hang on to those cards, go to trial, save them for trial, or put them on the table. Let me be very blunt, because the hour's late.
Right.
I'm learning in the course of this process that there's information that hasn't been exchanged naturally.
Right.
You haven't had full discovery yet.
Right.
This will all come out in due course. Is there anything on your side of the case that you have concerns about that would influence the value of the case once they complete their discovery?
Yeah, one of the reasons that we're able to offer a highly competitive product is that we do use environmentally friendly, recyclable material.
Yep.
Now, there is theoretically the possibility of some contaminant getting into that antifreeze.
Did they come back? One of the questions we had when we left previously was the evidence that they had to support some of their claims. Did they come back with any concrete information to say, well, this is how we're going to support our claim of diminution in value, or?
Yes. On the diminution of value, they have talked with the dealer who gave them, a figure, and so they expect that they will put in testimony about diminution of value. Here's what I'd like to suggest. If you want to talk with me about it further, or if you want to confer separately, that's fine. But if we want to move the process along, I guess I need a number, and I need your decision about whether to put the maintenance cards on the table.
Okay. Just give us about 3 minutes, and we'll be able to, and we'll give you an answer to both questions.
After conferring with his client, Mr. Stewart authorized the mediator to disclose the maintenance card information.
Here's their counter-proposal. It has two features. One is a number, and the other is a piece of information, which you may or may not be aware of, but it's important because it has a lot to do with their perception of the res ipsa loquitur case. Their proposal is $100,000. Now, I know that doesn't sound like a very big move in your direction. They believe that you won't be entitled to a res ipsa instruction.
The mediator then revealed the maintenance card information and explained why Foster believed that it would undermine Waltham's res ipsa loquitur theory.
In light of that information, it may be that you want to take some time and let that information settle in and think about it some more.
I guess tell me where I'm thinking wrong, but we still have undisputed evidence that for at least 16 trucks,
yes,
there was no problem before Foster's,
right,
and there was a problem immediately afterwards.
Right. And the problem is that the 5 trucks that exhibited the problems before the Foster antifreeze suggest that there's something else going on. If we took a break so that Tom and Craig could confer, maybe Craig would put on the table these maintenance cards, and you could look at them, assess what they mean in terms of your valuation of the case, and then we could come back and I'd meet with you separately so that you could let me know where you want to go next. Would that be all right?
After taking a break to review the data and consider its implications, Waltham met again with the mediator.
Let's talk about where we go from here. What are your thoughts?
Well, as I said, our primary objective is to be made whole.
What if you said to them 320, but you need a strong signal from them? Why? Because, in fact, there's reason to doubt that this sample that they've presented is the actual sample of what went in the trucks.
That's fine.
Okay. So Craig and Linda, I've talked with Tom and Nathan about the import of the maintenance cards, and they've come back with a proposal to settle the case at $320,000. Now, I want to explain to you how they got to that number in just a minute, but I guess the real import is that having come from $1.5 million to $750,000, I think that 320 number represents, very substantial motivation on their part to settle the case. Mm-hmm. I'll give you the rationale, and then there's also some information that they asked me to share with you. They're willing to put the good faith issue completely to one side, 100% to one side for the moment, for purposes of settlement discussions. Yep. Focus on the make-whole number and discount that by a third, which gets them to 320. Now, the information they asked me to share with you is that they've retained an expert. You'll get all this information in due course through answers to expert interrogatories, but what their expert has concluded is that based on the physical evidence that this expert has evaluated, there's reason to doubt whether the sample that Foster has preserved is in fact a sample of the same material that went into the truck engines. And they're not saying that it was different intentionally or negligently. They just don't know. Mm. This is what the physical evidence.
They're still at, their make-whole number is $487,000. That includes $60,000 in legal fees. We can't help the fact that they've spent $60,000 in fees. We've spent $60,000 in fees as well. That's a wash on either side. And interest, yeah, they get that if they win the case. Mm-hmm. So I'm taking those out. The balance of $344,000, if they wanted to assign a probability of success factor to that $344,000 number, which I think is a realistic number, mm-hmm. more realistic, I would again put it half of that, which whatever that makes it, whatever that is. Yeah. But here's what I think.
Could I make a suggestion, yeah. though? Because I'm thinking about it from they're the ones who are going to have to agree if there's going to be a settlement. And from their standpoint, the interest factor might be one that they might be able to factor out because it's not real. But the $60,000 they've spent on attorney's fees is real. And so what you might want to do, if you're going to apply a 50% discount, is say $344 and the $60,000 of attorney's fees, aggregate those two, and if you apply a 50% factor,
you're at 200.
Yeah.
All right. Tell you what we'll do. We came at this a different way,
mm-hmm.
but we're about at the same spot.
Mm-hmm.
Their actual out-of-pocket cost for the 21 trucks, which was not 10,000, in fact was 9,800, which we rounded up, turns out to be $206,000 for overhaul.
Mm-hmm.
We will give them $206,000 for overhaul on the condition that they enter into a one-year contract for diesel fuel only.
Let me ask you this. Have you thought about, let's say for one reason or another, because of all that's happened,
yep.
they're just not comfortable doing business. Would you price the settlement differently without the diesel fuel contract? In other words,
yes, we would.
Yeah. Would you be willing to go 200 without the contract?
Well, we calculated, at least in our discussions, that the contract was worth in upwards of $50,000 just based on improvement in our reputation. The confidence that might be shown by Waltham having an ongoing contract with us might undo some of the damage to our reputation that we've incurred.
Mm-hmm.
And also just
Look, we haven't brought this up up to this point, but the fact of the matter is we came that close. In fact, your dad came that close to wanting us to bring a third-party complaint against his law firm,
mm-hmm.
because at one of the it was by happenstance.
Mm-hmm.
a guy from his law firm, as our salesperson was trying to close a deal on antifreeze. As a matter of fact, his partner came over. I don't know what he was doing there, whether it was for a deposition or whatever. And he says, "Are you still trying to peddle that crap antifreeze of yours?" The customer
for defamation.
The customer said, "What are you talking about?" and walked off.
There's a concern about Foster's reputation, concern about what Waltham and counsel might be doing, but also a concern about what litigation itself might do.
We're prepared to make them whole with regard to the money which they spent on the overhauls, and we're prepared to offer them an absolute first-class market deal on fuel. I think that's fair. Okay. We want to talk about legal fees. We want an answer on our proposal, and let's see what they say.
Good. Okay, I will communicate this and see what happens.
Okay, great.
Good. Thank you.
Thank you.
At this point, both counsel had to leave the session. The mediator would ordinarily have adjourned the process to allow them to return. Because of the special constraints of filming, however, and with the consent of all the participants, the mediator decided to continue on a pro se basis.
Nathan, I understand that because Tom had to go to court, two of you have conferred. You've got authority, based on your conversation with Tom, to talk with me, and Tom's comfortable with that. And you're comfortable with it?
We are.
Okay.
Tom did a risk analysis of, what he thought would happen if we went to court. 70% on the 210 claim, 50% on the 134, interest at 24% and 20% on the bad faith. Came out at 294. We throw out the bad faith claim, comes out to be 253,000, and that's what we'd be willing to settle for. Yeah. I know that's a little more than what they offered. They wanted the contract for the year. It'd be very difficult for us to have a contract relationship, a continuing business relationship with them, considering everything that's gone on, both sides. Our break-even point, as you pointed out before, was essentially 213. So if we started at 213 and took our figure 253 and found someplace in the middle, I think we could settle.
Yeah. Well, that's helpful. I mean, it's helpful in the sense that I think that your proposal, your suggestion of that range, 253 to 213, somewhere in between, gets the two sides close enough so that at some point it no longer makes sense to spend $100,000 or $20,000 or whatever it's going to take to try the case. So I guess what I'd like to do is to hear from you a specific number you'd like me to present to the other side in response to their proposal. I take it that the diesel fuel contract is not...
It's not an option.
It's not something you want. Okay. It has very significant value for them. What if, sometimes what I do when the parties are, at an impasse, and I'm not sure if we are here, but we're very close to being at, a tight spot where 206 is going to be hard for you to come to. I think coming north of 206 is going to be hard for them to come to. Sometimes what I do is I make a proposal. So here's what I'd like to suggest. 233, 206, 220 is about the midpoint there.
220 with no contract.
With no contract and confidentiality. I don't think you're going to have a deal if there's no confidentiality. That's a...
Okay.
Yeah. Okay. I'm going to make that as a proposal.
Okay.
I'm going to ask you to let me know if it's acceptable. If it's acceptable, I'll keep that under my hat. If they accept it, I'll report that there's a deal. If they reject it, I'll simply report to both sides that there's no deal.
Okay, we'll accept it, but this is it.
I understand. Okay.
Okay.
Thanks. Let's cross our fingers, see what happens. If you look at the 206 and you factor out the attorney's fees and you put some value, some number on the risk with respect to the other trucks, I've got it in my mind that a settlement at 220, that's my number.
Okay.
Might,
No contract, or with a contract?
With no contract, but with confidentiality.
Okay.
That's a number that I would be willing to propose and recommend to both sides. Bear in mind that if you look at the bargaining, I'm going to use the flip chart, if you don't mind. If you look at the bargaining that's gone on here, from 1.5 million to 75,000, and 750,000 to 100,000, and 320,000 to 206 plus a contract. Spelling's a little off there. Contract. I think we used to use K for contract in law school. That my proposal of 220, it represents a significant step in their direction for your side. It represents an enormous step in your direction from their side. And but I based on everything I've heard, it's a number that I would strongly urge you to consider, and I've strongly urged the other side to consider.
I need some time to think about it. I need to talk to my father.
That's very understandable, and I'm sure he will feel good about being part of the process. And, and I know in a family business that's very important. And you may want to consult with Craig also. But I think both sides could wind up feeling that this was actually a reasonable place to put the case to rest.
Okay. Thank you.
Yeah. Thank you.
So what happened?
Well, the parties talked to their counsel and eventually accepted the mediator's proposal.
This is the first in a series of videotapes entitled Mediators at Work, in which we videotaped both this case and another age discrimination case. If you're interested in learning more about these videos or in obtaining copies, you can contact the Case Clearinghouse at the Program on Negotiation at Harvard Law School. The number there is 617-495-1684, or you can visit the Program on Negotiation's website.